Okay, it is Monday, April 29th, 2019, and this is week five of constitutional law, which means you have one more week left, and it's actually a week from tomorrow, the course actually ends. And so we're going to have a lecture today, and then you're going to discover we're going to have another lecture on Friday for week 6. I've sent you the PowerPoints for weeks 5 and for week 6 already. So you want to make sure that you have accessed those. So I'm going to go ahead and share my screen. Okay, so you see my instructor information there. And now let's get down and take a look at the rubrics. So we're at week 5. Voluntariness of a confession. Explain what makes a confession involuntary, including reasons found through research. I'm going to talk a little bit about that tonight. Find and summarize a case where a confession was held to be involuntarily given and explain the court's holding in that. Use proper case law citations. That means you must cite the case properly. Corso APA also requires citations in the body and references at the end for a total of 80 points. Okay. Let me see what you're asking. Week 5 on the outline has the wrong chapters. They say 5 and 6. Okay. Instead of 10 and 11. The PowerPoints, I think, are 10 and 11, right? That I sent you. Okay, I'll have to send chapters for that. Well, they're all together. Wait a minute. No, week 5, the outline. Okay, I'm going to go back while I got you now, and I'm going to look at that in just a minute. Just hold on. All right, let's go back to this. Okay, so now your course project coming up for this week interviews a law professional about Fourth Amendment area, outline what is covered and who the subject is, and then you're going to provide that. Now, be aware that this should be at least, I think it's 2 pages. I'll have to take a look at it. All right. And then we're not going to talk about week 6 because notice this is that the last lecture for this week, for week 5 on Tuesday, and that this Friday, May 3rd, 8:30 to 9:30 p.m., there'll be a lecture. Now, remember the reason for that is because the course ends the following week. Okay? So now let's take a look at, see if we can check on that information that you were saying to me. Okay, so chapters 10 and 11. So now let me take a look at what I emailed out to you. Okay, this is the PowerPoints I sent out to everybody for week 5. Should be 10 and 11. Oh, where did 5 and 6 come from? That's wrong. Where did that come from? Okay, I'll fix that. Okay, let's create a message real quick here to each of you. Fix that up right now. 10 and 11. Okay. So let's do this. Thank you for pointing that out to me, because I guess because I was doing a lot of stuff that day. The PowerPoints. Okay, let me go back, pull them up. Oh, I see what happened. Yeah, 10 and 11. And then let's do 10 and 11. Okay. Let me move my little picture out the way. Submit it. Come back down here. Submit it again. And come back down here again. Move that mug down here some more. And submit. Okay. Okay. Okay, let's submit it. Okay, let me go to my course messages and check my inbox. Should be there. PowerPoint, correct PowerPoints for the week. Okay, there, now you got them. 10 and 11. Okay, thank you for bringing that to my attention. As long as I'm looking, week 6, let me make sure we got the right ones. I think we do. 12 and 13. I think you got those. Check. Yep, yep. So you got the right ones for that. Okay. Okay, so now let's go back. Thank you for bringing that to my attention. So now you have the correct ones. All right. So now let's take a look at the announcement for this week. So in the 5th week, suspect rights will be presented. And you will read chapters 10 and 11 of constitutional law. And I now sent you the corrected PowerPoints. And then the activities, rights of suspects, which we're going to talk about. And then the discussion assignments. Assignment for this week is take it in the 5th. And the right to an attorney. So you should be aware. Remember, I told you early on that the important amendments in this course that really affect pretty much criminal law are the 4th, the 5th, and the 6th. So today, the 5th Amendment, and then the right to an attorney is the 6th Amendment. Okay, 5th Amendment deals with specifically the Miranda case versus Arizona, and then the right to an attorney, the 6th Amendment. Finally, complete the written assignments, voluntariness of confession, and then the 4th Amendment project interview that we just went over. All right, let's take a look at the calendar real quick. Here we go. It's very simple. This is where we are right here. These are the reading assignments that I just went over with you, and then your initial posts through tomorrow, 11:59 p.m. Central Standard, and then your live lecture that will take place this Friday, I was telling you, and then your reply post for week number 5. So don't get confused. This lecture is about week 6, which would normally take place here, but because the class ends right here the next day, I need to give you some time to be able to move forward on that, okay? I really could have done it on the 2nd, but I decided I would do it on the 3rd because you'll probably still be working on your week 5 stuff, and you need to get a heads up for your week 6 stuff, because remember, your week 5 stuff is due on the 5th, and then your week 6 stuff is due on the 7th. So, okay, and the 7th is the last day. We won't talk about that in detail until next Friday, or this Friday coming up. Okay, let's get out of that. And then we're going to go to week 5 module. Again, let's go over the assignments. And the assignments are the 5th Amendment project interview. So you're going to interview one of these parties, a prosecutor, a public defender, or a private lawyer, a judge, or a police officer. One of these, and find out what they think about the Fourth Amendment. The Fourth Amendment. That's what I said 5th earlier, didn't I? But it's Fourth Amendment. Fourth Amendment that you've chosen for this particular. Oh, I know. Hello, Richard, Professor Wright. The Fourth Amendment is all about the project. And so that's where you're dealing with that. Remember, that's the search and seizure issue. The discussion post is the one I was talking about earlier that had to do with the 5th and the 6th Amendment. So basically, for this week, you're going to be dealing with all 3 of the amendments. So you're going to complete a 1-page report outlining what you covered in this interview. I read you citations and references. You could include a resume from the person you interview if you desire it. It's okay. You don't have to. But you should proofread your paper. I'm grading you on the content of your paper. And again, sometimes people won't want to give you resumes, or I won't penalize you for that. Now, it does say a 1 page. If you want to do longer, that's fine. But make sure that you provide citations in the body and references at the end, cover page and everything. And then the voluntariness of a confession. You're going to write a 1 to 2-page paper that includes the following issues. Remember, the voluntariness of a confession deals specifically with the 5th Amendment. So you're going to explain what makes a confession involuntarily, and then include reasons that you're able to find out from your research. And please do not use your textbook as the source throughout your paper. You will get dinged for that. You can start with it, but I want to see research. Notice the key word, through research. Textbook is not research. It's already a research source. Find and summarize a case where a confession was held to be involuntarily given, and explain the court's holding. Use proper case citations. You already heard me say that. And then grammar and so forth. And this is APA. It is APA. Remember, all written assignments are APA. Probably the only thing that's not really APA are the briefs themselves, but you have to follow the format there. And then your discussions. Your discussions, taking the 5th, which has to do with the 5th Amendment, and the right to an attorney, which is the Sixth Amendment. Okay? And they talk about cases based on your assigned reading and resources. Share your views on the right to an attorney as guaranteed by the Sixth Amendment, as I said earlier. Does the right have more to do with the Sixth Amendment or with the celebrity money, as in the OJ case? I don't want you to get hung up too much on the OJ case, because the Sixth Amendment didn't play as much. What some people believe is because he had a lot of money, he got some top attorneys. But the Sixth Amendment, made famous by the, and all of you should know this case, Gideon versus Wainwright. It is very important, and that should be mentioned somewhere in there, because that's the origin of the Sixth Amendment right to an attorney. Okay, what happens to this right when a person can't afford an attorney? You should already know that information from your research and so forth. That's the discussion post. Okay, and then your live lecture at the end. So that's what we have for week 5. Now let's go into what I'm going to talk to you about in detail here for the next 20 minutes or so, maybe a little longer. And we're going to talk about the rights of suspects. As you already know, and I said this already, that the famous case of Miranda versus Arizona, and see, when I say court citations, this is how court cases are cited in the United States Supreme Court. What this means is this case is found at the 384th volume of the United States Supreme Court Reporter at page 436, and that it was issued in 1966. It is the cutting-edge decision on Miranda rights. Almost everybody knows the Miranda rights. And from that point on, there are rules that are listed here that the Supreme Court laid out in this case. Now, let me give you a little history of something that you should know about this. I have some up-close and personal knowledge about this case, because the case, of course, came out in 1966. I was 16. However, in 1975, I started law school at Northwestern University School of Law. My professor was a gentleman by the name of Fred Inbau, I-N-B-A-U. You can research it. And Professor Inbau was the author of a book called Interrogations and Confessions. And that book was written with he and another gentleman by the name of John Reed, R-E-I-D. And the techniques that were outlined in that book were techniques that were the subject of the Miranda versus Arizona case. And if you ever look at the full case, you will see in the footnotes some references to these techniques and citing the book, which I had to, we actually used the book in our class because it was written by the professor, but learned a lot. And what our professor felt personally, that he was maligned by the United States Supreme Court in the Miranda versus Arizona. He took personally the fact that the Miranda rights were established. We used to call him Freddie the Cop, because he was always pro-prosecution, never pro-defense. And he always thought the prosecution was always right, and the police were always right. And so anyway, he felt that these little loops and hoops that the police were going to have to go through were, how should I say, crippling good law enforcement. But the Supreme Court says no, because there was a lot of trickery involved and taking advantage of individuals, and that they could be found guilty on statements that are given without giving these rights. such as the first one, the right to remain silent. Now, the right to remain silent, you're going to discover when we talk next section about self-incrimination, that means very simply this, that if you are arrested, and by the way, let me just say this up front. Miranda warnings come into effect when a person is under arrest. Any questioning that's done when a person is under arrest, that person must be Mirandized with these rights that we're going to go through. If they are not, and it is established that they're not, then the statements that are provided cannot be used in a court of law if the attorney for the defendant files an appropriate motion to suppress those statements. And the court is obligated to make sure that these are done. Now, most departments now, and I had to do this when I was a police officer, we read the rights off of a pre-printed card. It is not required, but it is important because if you mess up the rights and give them to someone, you can find yourself in a pixie. I, as an attorney, many times have police officers in court, and I would ask them, did you give the Miranda warnings to the defendant? And they would, of course, always say, of course they did. So anyway, do you know those rights? And the smart police officer would say, yes, I do know, but we use a pre-printed card. And then he would use the card, or she would use the card, and read it directly from the card. And it would be questioned by the prosecution to determine that that was the technique that was used, which is a way of protecting the rights of the individual. However, there were some police officers who tried to wing it. And if they didn't get them right, then, and they tried to correct themselves, as a defense attorney, I would have done what we call impeach them or make them look bad in front of the trier of fact, particularly if it was a jury, because then they were operating unprofessionally, and the trier of fact, the jury, would see that and would sway towards the defense. So anyway, so this case, you know, my professor, every time a case came up, and there are many cases that came up since that time, based on the Miranda issues, he would file what we call an amicus or amici brief, which is called a friend of the court brief. And that brief would be submitted on behalf of the National Association of Prosecutors. I think that's the name of the organization. And it would be a brief that was submitted to the court for them to consider chipping away or overturning. His dream was to have Miranda completely overturned, as I said, because he took it personally. Well, he passed away, I don't know when Professor Inbound passed away, but it's been a few years now. And, of course, Miranda is still the law. And I just don't see it being changed. So just a little history for you, background-wise, that you wouldn't get from anybody else that was teaching you this except me, because of my personal experience that I had with Professor Inbound, who was directly involved with the Miranda case. So anyway, so you have the right to remain silent. And what that means is that if at some point, and by the way, how do you know when a person is under arrest? It's very simply this, and I've said this in many of my criminal law classes. I've said it in my 11-week constitutional law classes, that when a person is not free to go. So a person can very simply ask, am I free to go? And if they say, no, you are not, then you are under arrest. And anything they ask you, you need to remain silent, because that goes to the next thing that's coming up, the self-incrimination issue. Okay? So you want to be aware of that. So you have the right to remain silent. And then it continues and advises that anything you say can and will be used against you in a court of law. In other words, if you decide to start talking, that statement is going to be taken out. Now, it's going to have to be a voluntary statement, one that not that was beaten out of you or forced out of you or anything like that. You just provide the information. So you're given a warning. It's telling you, and it means what it says, good people, that the statements will be used against you in a court of law. So it becomes evidence for the prosecution. Then it tells you that you have the right to an attorney. And that goes back to the good old Sixth Amendment that we talked about, and that how it is important that individuals have attorneys, competent attorneys to represent them so that they have their rights protected, because the average defendant is not smart enough to be able to do that. Even attorneys I know. And I was hired by one attorney in a criminal case a long time ago. And we won the case up to a point, and then some evidence came out that he didn't share with me. And when it came out, that was the end of the case, and he ended up being convicted and incarcerated, lost his license and everything. But you have a right to an attorney. And then it tells you that if you can't afford one, then one will be appointed for you. And generally that means the public defender. Generally, that's what that means. So these rights should be understood by the party that's hearing them. So it says an example here that if the suspect speaks Spanish, then he should be given a warning in Spanish. If a person speaks Polish, they should be given it in Polish, or whatever their native language is, so that they can understand it. And it has to be a voluntary waiver of the rights. So if you don't know and understand these rights, because they'll ask you, about these rights, do you understand them? And one of the things that is important for you to be aware of is that, listen, and this is what we always tell individuals, do not talk to the police, because if you start talking to the police, you have a tendency to incriminate yourself. And once that evidence comes out, unless we can prove that it was coerced out of you, beaten out of you, or something like that, we will talk about that in a little bit, because there was a police officer, Commander John Burge, B-U-R-G-E, if you want to do some research, that happened in Chicago. And I was actually an attorney for a few of the people that were victims, and they were forced to give confessions by cattle prodding, by violating what we call the Geneva Convention, and there was no voluntariness in those statements. So anyway, these are a few things that you should know about Miranda that I'm going to talk about, and then we're going to move on. First of all, let me move this up, is that voluntary intoxication is not a defense to voluntariness. It is, you cannot voluntarily get, and I talk about this in my criminal law class, you can't voluntarily intoxicate yourself and use it as a defense. So that means if you get drunk on drugs prior to being arrested, you can't later claim you did not voluntarily waive your rights due to your intoxication. But if you were unknowingly drugged, or a Mickey was slipped in on you or something like that, then you could possibly contest the voluntariness of the waiver. So you can't have it both ways where you go in there drunk. So a person who's arrested that's drunk probably is, we would argue, even if it's voluntarily, that they were not in their right mind. And usually a jury will understand that point. And some will get too really deep. That's why when we pick jurors, we don't want jurors who are lawyers. I was never selected for a jury. I was always excused. And we don't want to pick law enforcement people either, and people that work in the law, period. So because you're too cerebral and you will overanalyze stuff, you don't even try to look at the facts. So anyway, the bottom line is, to the point, is that needless to say that if your intoxication is voluntary, it is not a waiver. You are going to be stuck with what you say. And then the officers can lie or tell stories to the suspect to get him to talk. See, now this is some of the trickery that's involved here. For example, an officer can tell the suspect that if he is honest with the officer and tell the officer everything, he will get to leave custody, even if that's not true, which is why I said what I said earlier. The first warning, you have the right to remain silent, and you need to exercise that. And if you read the Miranda case, which is very long, you will see that the techniques were borderline trickery, but they were the individual was very, very, very much forced to give the confessions and statements that were involved in the case, and that there was some trickery, but there were techniques to twist the person's arm, so to speak, not physically. Don't get me wrong here, okay? So trickery by the police is okay. So again, the best practice, don't say nothing, won't be nothing. The rights can be invoked at any time during the interview, and so what that means is that if the officer starts to, if you say you waive your rights and you start talking, and then you say, I'm not talking no more. Soon as you do that, the rights kick in, and the police officer or interrogators cannot ask you any more questions. And they cannot say, come back to you later and say, did you change your mind? Won't do it. It's not going to happen. Anything that up to that point. But after that, when you invoke it, the officers must stop. Must stop. A suspect must actually verbally invoke. The silence is not enough to be considered of invocation of the rights. Now, here's the deal. That sounds funny. It says that the silence is not enough to be considered an invocation of the rights. You don't have to say you don't have to say I want to exercise my Miranda rights or my right to remain silent. You don't have to say that. But it says here that just because you are quiet is not enough to be considered an invocation of the rights. So if you read this case, this is a 2010 case. Pretty much what it says is that if the person is silent and they do something to indicate, you know, that they did something or something they volunteered, then it will be used against them. So, but a statement, again, is that the suspect must actually invoke the right. We usually tell our clients, don't talk. That's just don't talk. And if you don't talk, then you can't get it. Let me see what she's saying. If you ask for an attorney, no. Absolutely no. That is an invocation. That is a right to remain silent. No. The answer is no, no, no. No. Okay? Earlier you asked, can we do an introduction for the person you interview? Sure, you can do whatever you want to do with that written assignment there. But anyway, back to the question, no. That is the whole essence of it. If you do those things, then you're invoking your rights. And that's what I said. Anytime you ask for an attorney, that's it. Stop, cease questioning. That is right there the most direct way of invoking the Miranda rights. So a suspect must be in custody. Remember I said that. subject to interrogation in order to receive warnings. And there's a whole bunch of cases. If you click on that, you'll see them. I'm not going to do that. That deal with the issue of what is custody. I already told you pretty much what custody is. Custody is very simply determined, and we tell people this. You ask the question, am I free to go? Am I free to go? That's why the Terry stop, which is on the streets, is not a custodial, because it stopped for a brief pat-down search, ask a few general questions, but it's not there to start questions that fit in Miranda. Because if you do, then that person is going to have a problem. Because, the key is, are you free to go? That is what custody is. You do not have to use the words or hear them say the words, you are under arrest. You people hear that, but you don't. It's based on the ability to be able to leave. That's cut and dry. When you read these other cases and look through them, you'll see that that's the essence of it. That's the thing I always teach my students. All right? So that's Miranda versus Arizona. As I said, it is the most revolutionary thing that has happened, and a lot of law enforcement people don't like it until they get in trouble, because I represented some of them. And when they get in trouble, they love it. They love it. But when they're doing the job, they don't like it. The bottom line is that it's there to protect the right of the individual to not incriminate themselves, which is now where we're going to go to directly to what the Fifth Amendment says. And so here's what the Fifth Amendment says. And reading it verbatim, no person shall be held to answer for a capital or otherwise infamous crime unless presented by indictment or grand jury. Okay, that's the bigger part. Except in cases arising in land or naval, and I'm going to skip over that. Nor shall any person be subject to the same offense twice. That's double jeopardy. Nor shall be compelled in any criminal case to be a witness against themselves. And what that means is this. First of all, the burden of proof is beyond a reasonable doubt. That burden must be satisfied by the prosecution. The defendant does not have to take the stand. The fact that the defendant does not take the stand is not constitutionally to be read as that they're hiding something, except they really are hiding something. And oftentimes what is hidden is one of two things, and I had this with my clients. If they have what we call diarrhea of the mouth, that meant that they just want to talk and talk and talk. They can get tricked into just talking, then they were dangerous. And so they could mess the case up and incriminate themselves. Because once they take the stand, then they're fair game for the prosecution, and there are certain parameters that I have to operate in terms of objections to try to break it, but the evidence will get out there. The other issue is this, and this is a very important issue, is that if a person is a repeat offender, has committed, is a recidivist, has a record, that record can be used against that person to prove that their credibility is not so great. So then here's what happens is that the jury and the judge, but really the jury in this issue, they learn that the person's been convicted of such and such a crime. Guess what that does? That makes them say, okay, well, if he did that before, he probably did this too, or she did this too. And that's the deal. And so the Constitution says it's an unfair thing when a person doesn't put themselves in a position where they take the stand. So it is a strategic move that was used by defense attorneys, but we use it because the Fifth Amendment says that we can do so. All right? And then due process of law, we're not gonna get into that. I think we've even talked about this before. Now, when a person takes the fifth, as you are going to discover from your discussion, it's Fifth Amendment. A person one time says, "I drink the fifth." No, that's not to drink the fifth. You take the fifth. You plead it. What you're saying is that I'm not going to testify. Have you seen situations even before Congress where a person is testifying and they will not answer the questions, and they will have on a card saying, I exercise my rights of the Fifth Amendment and won't answer the questions because they tend to incriminate me. What they're saying is that they're not admitting the statement, they're exercising their fifth. And what happens during a legal proceeding in one of those as well, one of those hearings, is that if they believe that it incriminates them, the statement of information, then it's not going to take place. Now, the most important thing that you should be aware of is when a person pleads the fifth, they do not plead the fifth in front of the jury. This is done outside the ears of the jury, and it's usually prior to any testimony given. If in the middle of a legal proceeding, a judge will generally reset the jury and inquire further. The judge agrees that he will, and the person will incriminate themselves, then the other side may request a mistrial and of any previous testimony that is stricken from the record. So it's a very, very careful thing there. The court has that obligation. I always tell people it's a problematic situation when you have a bench trial. But the Fifth Amendment kicks in and really is there to protect individuals from judge or jury. However, to be honest with you, judges are supposed to be professional enough, and I put that like this in quotes, that they will not let that affect their decisions, except one problem that most judges have, or every judge I know have. They're humans, and humans have a tendency to develop biases, and it shapes some of the actions that they do, okay? And, you know, we don't have robotic judges. If we did, it would be a problem too, because they'd be programmed by some human. So the point of the matter is this, is that that individual is protecting themselves by taking the fifth from being incriminated, because the questions that are asked could tend to incriminate them, okay? It's almost like the right to remain silent, but we call it pleading the fifth or taking the fifth, one or the other, okay? Any questions so far? Okay. So now for the next few minutes, we're going to deal with, because we have about 15 minutes left, still under the Fifth Amendment, a person has a right to request counsel. Now, remember I said the Sixth Amendment goes with that. That's where it originated. But under the Fifth Amendment, right to request counsel when they are subject to custodial interrogation. And that right was established as the right, the last right, the third and fourth point. You have a right to an attorney. So that's when they utilize the Sixth Amendment to implement the Fifth Amendment Miranda warning. So the person who has been formally charged is custodial, and under the Sixth Amendment, remember I talked to you earlier, has, after they've been formally charged, the prosecutor may not speak to the defendant without his lawyer present. So you see why I said that earlier, that if a person asks for an attorney, that they have to stop, because it would violate their Sixth Amendment and Fifth Amendment. You got that? Okay, that's fundamental. That's like we call criminal law day one in law school. Okay, so let's give this hypothetical here. I like this here. This is a pretty decent one. Let's say Sam was released and no formal charges were filed against him at that time. If Officer H brought Sam to the police station to interrogate him again at a later date, then Officer H would more than likely give Sam his Miranda warnings again. That is so important, because if he does not, they can't say, oh, it was given to him when he was here the first time. Not going to fly. The Miranda warning should be contemporaneous with custodial activity. So if he was released and then taken back, then they would have to do it again. And Sam would have the right again to invoke his right to counsel again. Say, I don't want to talk and I want my attorney. Okay? Now, if a person says they don't want to talk, they can still ask them up to the point that they say, I want an attorney. Then they got to cut it off. So they could continue even after they have given the warning and the person doesn't respond back and say, I want an attorney. They can still ask him. And the person can remain silent and not do anything. But the best practice that we teach as defense attorneys is to tell our clients the very first question, say, I want an attorney. As soon as you say that, you close the door to all interrogation. So if Sam did not invoke this time, a court would probably find that Sam's statements were made at the second interrogation would be allowed, because so much time had passed between the original invocation and early, and clearly Sam understood his rights. So that's the point. But they still have to ask him each time, even if they can't assume that he knew. But if he voluntarily waives it, then Sam, you messed up. That's it. So if a suspect is in custody on one charge, and while that charge is pending, the police are investigating him on another, and they bring him in for interrogation room to ask him about the new crimes, new warnings need to be given, because it's something else. So the bottom line is that the suspect must also invoke their right to counsel as well, or to have an attorney present. However, the police may not question him regarding the case that is already pending and for which he is formally charged without his lawyer's presence, because that's already established. Okay? Are you confused, or are you okay? Okay, good. And the key thing that I always tell students is always just keep in the front of your mind this. The best practice is don't talk. The next best thing is, I'm not talking and I want an attorney. Or you can say, I want an attorney, which means there shouldn't be any more questions. Now, what you can do, you can mess up, is you can voluntarily say stuff. And then, you can mess up there in that situation. That nobody's, you left in there and you start talking to yourself out loud and so forth and so on, you can mess up. So when it says silent, it means what it says. For example, if Sam is charged with the retail theft and he is later brought into custodial interrogation regarding a domestic violence case, then the officer must advise him of his Miranda warnings and he must invoke again. So, but Officer H cannot ask Sam about the retail theft, since the Sixth Amendment protects Sam. He cannot question him without his lawyer present at that time, but he can ask him about the domestic violence situation there. So the key thing is that it's in place to make sure that individuals find themselves protected. Any questions about anything that we talked about today? Because I explained the right, what the module says we should do against self-incrimination and the impact, and then discuss what point the Miranda warnings, identify what issues are raised if there's a confession given in a case of voluntary confession. Double jeopardy means you can't be tried for the same crime twice. Now, let me say this. Double jeopardy actually does not kick in if you're tried in federal court and state court, because there are two different tribunals. But if you are tried in a state court and then you're tried in the if you're tried in the state court and then another state court tries to bring you back on those charges later, it can't be done. It can't be done. That's the argument that R. Kelly is arguing about some of the things that are happening with his current issues, is that double jeopardy. If you ever saw this movie, there was a movie, a really good movie. Ashley Judd, I believe, was in it, and it was called Double Jeopardy. And in that movie, let's see, the reason why there's a difference is because there are two different processes that take place in the federal and state court. There are different crimes that you're charged with in the federal court and different levels of it. That's why. There's been arguments tried over and over and over to say, well, it's the same facts. Yes, but the law still stands that you can be tried in both courts because the cases haven't been overturned by the United States Supreme Court. All right? Okay. But anyway, this movie, Double Jeopardy. Did you ever see that movie? Are you familiar with that movie? Yes, yes. So you know what happened there is that Ashley Judd was charged with killing her husband, went and served her time, and came out and then found out that in reality he was alive, had changed his identity, and moved to New Orleans. And she tracked him down there. I love that movie too. I do too. I like Ashley Judd, but I really enjoy that movie, and I like what happened in it. Because what happened is that when he changed his identity, you notice what happened, and she went after him. And Tommy Lee Jones was her parole officer, and was trying to watch out for her. Well, in essence, what happened is that she ended up tracking him down. But then remember what happened in the movie. He tried to kill her to get rid of her. Remember, he put her in a casket in a cemetery and left her there. She woke up, she was in a casket, and there was a dead body next to her. And then finally what ended up happening is that at the end of the movie, he ends up, the guy who's her husband, tried to kill not only her, but also the parole officer. And she got a gun, and she was able to shoot him. And you know what happened there is that because of the fact that the law said that, and this is aside from the double jeopardy, that because she was still married to him, that all of that stuff belonged to her. You remember? And that the woman that he was with, who was really a friend, talking about friends, loose definition of a friend, friends like that, who needs enemies, you know. But at any rate, they said at the end of the movie, because of the fact that you've already served time for this crime, you killed him, you can't be tried for killing him twice, okay? And you can't be, not only can you not be tried, because she was found guilty, remember, and served time and was released on parole. So the point of the matter is that they couldn't retry her for killing him the second time, aside from the other reasons that self-defense might be in there, but just going straight to the double jeopardy part is because she had already suffered jeopardy in terms of being in jail. And so that's a very good movie, and it lays it out really good. And that's the title of the movie, Double Jeopardy. I have it just a few feet from me here, my TV. It's on my VCR, DVR, and you know, I look at it. But yeah, it's good. It's good. I like it. I really like it. And I think justice was definitely served, and injustice was done to her because she served those years, you know, in prison. That's too why, if you know some of these wrongful conviction cases, when the individual serves so many years in jail, then they come out and some DNA evidence or some other evidence determined that they didn't commit the crime, they can still try the individual because of the fact they said, well, the evidence was gone. But there's arguments that double jeopardy is set in because they've already served jeopardy for something they didn't do, which is almost like what she did. So you couldn't really try them again. So bottom line is that that's what double jeopardy is. You can't be tried for the same crime twice. Two different instances of the same kind of crime, you can. And then I already talked about the right to effective counsel. And effective counsel means very simply that your attorneys are not sleeping in court. Let me tell you something. There were cases. I had a friend that came out of school with me, and he got disbarred because he was a drinker, and he went to court several times and defended people in criminal cases, and they were convicted. And they said that they argued that it was ineffective assistance of counsel. Well, of course it was, because he was sleeping and he wasn't doing his job there. So the Sixth Amendment right has been interpreted to mean not just counsel, but effective counsel. And it doesn't mean that they might not make a mistake in the case, but that means very simply that a reasonable attorney trying to do their job, even if they make a mistake in it, that's different. That's when you get to the malpractice areas. So so that's it. It's about a minute, about 9:29, and I have shared everything I need to share with you. I do want to remind you that join me Friday night. Everybody should join me Friday night. At least come out and just say happy birthday. I mean, because that's my birthday. And, you know, somebody said, why are you working on your birthday? I said, well, I didn't work on my first birthday. I think my first 10 or 11 birthdays I didn't work, you know. But, yeah, I'll be celebrating that weekend, though, with it. My wife, she has to work, too, as well that day. So, anyway, it's 9:30. Oh, okay. Well, you got an out there, but make sure that you, you know, yeah. Well, happy anniversary. What number is this? 20. Oh man, I got you by 4. No, 5 coming up. Yeah, it'll be my 5th one. Will be 25th. Will be the 28th of July. So, but that's my 3rd one. Earlier, if I put the other ones together, I'd have a whole bunch, but didn't work out that way. But yes, my current wife, the one you saw in the pictures and everything. So that's my partner in crime as well. So, well, congratulations to you. And I always say this on Facebook, and I say this, and wish you a happy anniversary, and may God bless you with many, many, many more. So you only got 30 more to go to get to 50. Well, you get to 25, then you get to do something special, because that's what we're doing, something special. So I can't say on here what I'm doing, and the reason is because there's something else going on that I'm trying to surprise somebody with, and it has to do with students. So I can't say that what I will be doing for my 25th anniversary. At any rate, I'm going to say good night, and those of you who are able to be here that are not celebrating your anniversary, don't everybody come talking about, oh yeah, man. No, and don't tell me it's your birthday either, because I'm saying I'm working on my birthday. You can work on yours, but anniversaries, I guess you kind of gotta pass on that one there. So you're going to a concert, okay? Well, whose concert are you going to? What concert are you going to? Garth Brooks. Oh yeah, I like Garth Brooks. We have some issues politically, but I like Garth Brooks. I really do. But yeah, Garth Brooks, I do like him. I do like him. Oh, okay. I know that one. Okay. Well, that's cool. That's cool. Well, I'm gonna let you go. It's 9:33. The phrase that I'm looking for is self-incrimination. Give me that, and you get all your points. You got to give me that though by Sunday, 11:59 p.m. Central Standard Time. So with that, I'm going to say good night. Get your assignments in on time. A student already asked me a question. I am not accepting assignments from week 1, 2, or 3 anymore, because after week 3, we're in the second half. I'm only accepting late assignments from 4, and well, 5 is not late yet because that's not due until Sunday. So basically, week 4, if a student has not submitted them, then they can't. I might just bend a little bit and take 3s, but you're going to lose points on those 3s, a whole lot of points, particularly if there hasn't been any reaching out to me, as I talked about earlier in the quarter, to let me know so I can determine if it's an extenuating circumstance. I had one student already say to me that their extenuating circumstances was internet issues, but I never heard from them about it until I got the most recent message. So you gotta let me know. I gotta know when you're having a problem contemporaneously with it. All right, so good night, and I will see you Friday, May 3rd, for our final lecture. So good night.